Hi, I'm Elizabeth Gearhart. I'm here with Richard Gearhart, founder and owner of Gearhart Law, an intellectual property law firm. And we're going to talk about licensing, and in particular, the grant clause to do with licensing, which I know nothing about. So Richard, please enlighten me.
Well, that's why we're here, right? So licensing, that's a contract conveying rights in a patent from a licensor, usually the patent owner, to a licensee, somebody who wants to exploit the license and use it for commercial benefit. And so a lot of independent inventors seek to get licensing deals with large corporations. They have an idea that they'd like to see out there, and they'd like the company to adopt the idea and start selling it. In order to do that, they need to have a license agreement. And so kind of the key portion of the license agreement is the grant clause, because the grant clause grants the license of the intellectual property from the licensor, which is usually the patent holder, to the licensee, which is usually the big company. The focus of all that is the grant clause.
So if you owned a big toy store and I had an idea for a really cool toy, might be a cat toy, but then I could develop it. I think they probably want it a little bit developed, right? And then I could approach you and say, hey, do you want to be able to make and sell this cat toy? And you would say yes, but I need a license. I would have to give you a license. So then the grant clause would be the part where it actually says Richard Gearhart has granted the license to make and sell this product.
Yeah, I mean, that's basically it. It's usually a little bit more legalistic. So I'm going to read a sample grant clause. So here's a made-up one just for this video. The licensor hereby grants the licensee an exclusive royalty-bearing license in U.S. patent number blank, 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 in the territory defined as the United States.
Is there other stuff in the license then? Like, why is the grant clause? That's just like one little piece of the license. So I guess the rest of it is like how much money they're going to give each other or give to the person, and what rights they're going to give them, and how the money's going to be calculated and all that stuff.
So that's correct. I mean, there would be provisions for the amount of the royalty. Lots of other clauses go into a license agreement, but the grant clause is very important because it talks about specific types of rights. So in the example that I just read, you may have noticed that I said it was an exclusive license.
Oh.
So the exclusive license means that the patent holder can't allow anybody else to use that technology. It's an exclusive license. And so lots of times people who are trying to obtain intellectual property rights want the exclusive rights to use that intellectual property. So if you're the NFL, you can have non-exclusive rights. And in fact, you see team emblems and logos all over the place on all sorts of different types of fan gear. Those are non-exclusive licenses. And so a lot of different companies can use that logo or the team name on their products, right?
So you can have 5 or 6 different license agreements, each with the grant clause saying this is non-exclusive.
That's right. And then one of the other important pieces of the grant clause is the territorial scope. So you can grant your license rights to a specific state or region or country. So if you wanted just to do a license for the state of New Jersey and give somebody else the rights for the state of California, you can do that with the grant clause, and that controls the territory. In terms of scope, you can also grant it for particular products. So if a patent covers different products, then you can say product A is for this company and product B is for another company.
So I guess that if you're going to do a licensing agreement, you really do need a legal professional to help you with that. I can't imagine trying to wade through all this and make sure all the I's are dotted and T's are crossed without some help.
Yeah, we always recommend, it's very important that anyone who's licensing technology has the license contract reviewed by a legal professional. At Gearhart Law, we've seen a lot of different licenses. Some of them are very short and unsophisticated, and they don't give the licensor much protection. And so it's important to understand that you need to have the agreement reviewed by a professional if there's going to be any kind of transfer of rights.
Great. Well, thank you. So how can people find you?
You can find me at Gearhart Law. That's www.gearhartlaw.com. Or you can contact us by phone, 908-273-0700.